order indicating provisional measures, it took into account the possible consequences for Mr. Jadavi's situation of the availability under Pakistani law of any appeal or petition procedure, including the clemency petition to which Pakistan refers in support of its claim. In this regard, the court concluded inter alia, and I quote, that there was considerable uncertainty as to when a decision on any appeal or petition could be rendered, and if the sentence is maintained, as to when Mr. Jadav could be executed, end of quote. Therefore, there is no basis to conclude that India abused its procedural rights when requesting the court to indicate provisional measures in this case. In relation to the second argument, the court notes that none of the provisions of the optional protocol relied on by Pakistan contain preconditions to the court's exercise of its jurisdiction. The court interpreted these provisions in the case concerning United States diplomatic and consular staff in Tehran, where it ruled that Articles 2 and 3 of the optional protocol to the Vienna Convention on diplomatic relations and to the Vienna Convention on consular relations do not lay down, and I quote, a precondition of the applicability of the precise and categorical provision contained in Article 1, establishing the compulsory jurisdiction of the court in respect of disputes arising out of the interpretation or application of the Vienna Convention. Articles 2 and 3 provide only that as a substitute for recourse to the court, the parties may agree either to arbitration or to conciliation, end of quote. It follows that India was under no obligation in the present case to consider other dispute settlement mechanisms prior to instituting proceedings before the court on 8 May 2017. Thus, Pakistan's objection based on the alleged non-compliance by India with Articles 2 and 3 of the optional protocol cannot be upheld. The court recalls that only in exceptional circumstances should it reject a claim based on a valid title of abuse of process. In this regard, there has to be clear evidence that the applicant's conduct amounts to an abuse of process. The court does not consider that in the present case there are such exceptional circumstances that would warrant rejecting India's claims on the ground of abuse of process. Accordingly, the court finds that Pakistan's first objection to the admissibility of India's application must be rejected. With regard to the second objection to the admissibility of India's application, Pakistan requests the court to rule that India has abused various rights it has under international law. In its pleadings, Pakistan has based this objection on three main arguments. First, it refers to India's refusal to provide evidence of Mr. Jadav's Indian nationality by means of his actual passport in his real name, even though it has a duty to do so. Secondly, Pakistan mentions India's failure to engage with its request for assistance in relation to the criminal investigations into Mr. Jadav's activities. Thirdly, Pakistan alleges that India authorized Mr. Jadav to cross the Indian border with, I quote, a false cover name, authentic passport, end of quote, in order to conduct espionage and terrorist activities. In relation to this argument, Pakistan invokes various counter-terrorism obligations set out in Security Council Resolution 1373 of 2001. In its judgment on the preliminary objections in the case concerning immunities and criminal proceedings, the court ruled that abuse of rights cannot be invoked as a ground of inadmissibility when the establishment of the right in question is properly a matter for the merits. The court notes, however, that by raising the argument that India has not provided the court with the actual passport in Mr. Jadavi's real name, Pakistan appears to suggest that India has failed to prove Mr. Jadavi's nationality. This argument is relevant to the claims based on Article 36 of the Vienna Convention in relation to Mr. Jadav, and therefore must be addressed at this stage. In this respect, said that the evidence before it shows that both parties have considered Mr. Jadav to be an Indian national. Indeed, Pakistan has so described Mr. Jadav on various occasions, including in its letter of assistance for criminal investigation against the Indian national Kulbhushan Sudhir Jadhav, addressed by the Ministry of Foreign Affairs of Pakistan on 23 January 2017 to the High Commission of India in Islamabad. Consequently, the court is satisfied that the evidence before it leaves no room for doubt that Mr. Jadav is of Indian nationality. As already indicated, the second and third arguments advanced by Pakistan in support of its second objection to the admissibility of the application are based on various alleged breaches of India's obligations under Security Council Resolution 1373 of 2001. In particular, Pakistan refers to India's failure to respond to Pakistan's request for mutual legal assistance with its criminal investigations into Mr. Jadav's espionage and terrorism activities, as well as the issuance of what Pakistan describes as, and I quote, a false cover name, authentic passport, end of quote. The court observes that, in essence, Pakistan seems to argue that India cannot request consular assistance with respect to Mr. Jadav, while at the same time it has violated other obligations under international law as a result of the aforementioned acts. While Pakistan has not clearly explained the link between these allegations and the rights invoked by India on the merits, it is the court's view that such allegations are properly a matter for the merits and therefore cannot be invoked as a ground of inadmissibility. For these reasons, the court finds that Pakistan's second objection to the admissibility of India's application must be rejected. The second and third arguments advanced by Pakistan will be addressed later when dealing with the merits. The court now turns to the third objection to the admissibility of India's application, whereby Pakistan asks the court to dismiss the application on the basis of India's alleged unlawful conduct. Relying on the doctrine of clean hands and the principles of ex turbi causa non oritur actio and ex injuria jus non oritur, Pakistan contends that India has failed to respond to its request for assistance with the investigation into Mr. Jadav's activities, that it has provided him with, I quote, a false cover name, authentic passport, end of quote, and more generally, that it is responsible for Mr. Jadav's espionage and terrorism activities in Pakistan. The court does not consider that an objection.
तो कुलभूषण मामले में लगातार आईसीजे में भी सुनवाई चल रही है, लेकिन भारत के लिए बड़ी राहत की खबर है। पाकिस्तान को आईसीजे की तरफ से लताड़ भी लगी है और साफ साफ कहा गया है कि कुलभूषण जाधव की जो फांसी का जो फैसला है उसको रद्द किया जाए। मेरे साथ इस बुलेटिन में बस इतना ही। देश और दुनिया की खबरों के लिए देखते रहिए गुलिस्तान न्यूज़। नमस्कार।